Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Sadkovich. I'm Luke. Calum, how are you?
I'm good, Luke. How are you doing?
Good. I'm looking forward to getting into another one of our cases in the Look Back series, as I've just decided to call it.
We're throwing back to the key cases on commodities law these 3 weeks. This is part 2. This is the Empire Strikes Back of our trilogy.
It is, and we've got a corker of a case to discuss. A real classic, actually. Classic companies involved, classic piece of law to talk about, area of law. Classic players, the lords on this, some big names involved, which we'll get into in a moment. And we're going to explore conditions, innominate terms or intermediate terms and warranties, fun stuff in the context of a sale and purchase contract dispute. GAFTA terms were incorporated here, so yeah, well and truly in grain. What are we talking about here? Soybean meal is the commodity,
and it felt to me that this case had come out. It was a few years after, but it was very much in the era of the Hong Kong fur, which is that totemic decision, which they said you don't just have conditions, a breach of which entitles a party to terminate a contract immediately, and warranties, the breach of which only entitles a party to damages. You actually have this third way, this third path of the innominate term, which sits in between the two, and depending on the severity of the breach, could either be given the effect of a condition or given the effect of a warranty. And it was almost like that judgment was a new toy, and they were playing with it.
Yeah, exactly. I like that. It was this dance of, well, this was always the law. You know, this concept of innominate terms was always there, and Diplock Law Justice just shined a light on what the law has always been. But how far does it go? You know, we don't want a floodgate situation here. We want to rein it in. We want to make sure the contours of it are still there. And you're right. It is. It's like that new toy at Christmas, isn't it? Trying to work it all out. So just for a bit of context, the reason we're doing these kind of look back cases, this is a little different to what we usually do. This podcast is typically made up of cases that have just come out, whether it's in shipping, commodities, general commercial, some cases that are just for interest value or big news items. I think we've done the Scottish referendum decision. We've done a case on a dispute between wags of the English football team, and so on. But we're looking back at some cases in the commodity and shipping space, some real big cases, because I'm about to present a university course at the University of Wollongong on international shipping and commodities law. And as a part of that, I am looking back at some cases myself and taking Calum on the journey with me and chatting about a few of them as we go. So this is the second one in the 3, and we'll do one next week as well to round it all off.
This is the pre-listening to the course.
This is the reading that's not been prescribed, but we'll see if they pick it up. Okay, all right. So enough intro. The actual case is the Bunge Corporation and Tradax export case. This is from 1981. And it went all the way to the House of Lords. It went through 2 layers of appeal in GAFTA, which is an industry body, and they have their own arbitral system. It went through both levels there. It then went through 2, and then into the 3rd level of the English court system, all the way to the top. In the House of Lords, we had Lord Wilberforce, Lord Fraser of Tully Belton, Lord Scarman, Lord Lowry and Lord Roskill giving the judgment here. Lord Roskill gave the leading judgment, which all the other lords were at great pains to commend and agree with, and all commented on having the benefit of having read Lord Roskell's decision first in draft. And then many of them chimed in with their own comments as well. On that, Calum, I actually, the way that it was set out in the judgment was to read the shorter judgments first of the concurring lords, and then the leading justice of Lord Roskell. And I actually found, and this is not the first time I found this, that when you read some of the shorter judgments, they're quite condensed, concise. They get right to the point, and sometimes crystallize the principle in a way that's much easier to get at.
Yeah, it's interesting because by the time you get to the final judgment, when you read this sequentially or in the order that it comes out in the judgment, you know the background, you know the facts, you know the contours of the decision, and by the references that you've had to it from the other judges, you know exactly where Lord Roskell is going with his judgment. And in a way, it's almost anticlimactic. You get to Lord Roskell and you go, okay, well, now he's setting out the facts. Now he's telling us the backgrounds. Get to the good bit.
Yeah, it was one to read back to front, right? This case.
Exactly.
Okay, so by the time it gets all the way to the House of Lords, a number of arguments have kind of been stripped away. I just, in passing, thought to mention, before we get into the meat of the case, that there was a cross appeal on the question of damages, which wasn't explored in this decision at all. I thought it was really interesting, Calum, how there was a comment in here about, almost criticising the fact that this issue had been brought before the House of Lords, and that 14 other fact finders or judicial officers had looked at this question. It really shouldn't have gone all the way. And there was a comment in there about the incoming Arbitration Act that was about to be introduced, which set some parameters on and thresholds on appeals from arbitration decisions, and the Lord was actually saying, well, they'll be welcome because arguments like that shouldn't really be before us. That wasn't a criticism of the main point, but one of these other sideline issues on quantum. I thought that was interesting.
Yeah, I did find that interesting. I think it was Lord Roskell who said that, I derived some comfort from the fact that with the passing of the Arbitration Act 1979, this multiplicity of appeals should soon be a thing of the past. And I don't know Arbitration Act 1979 at all. It far predates me and predates the current Arbitration Act that we use, the Arbitration Act of 1996. But I wonder if that 1979 Act was when they introduced certain parameters around appeal. And I'm not sure at all. Maybe one of our listeners who knows about this can inform us in the comments when we post this. But maybe that's when they introduced the kind of concepts that we see now of the Section 67 and 68 challenges and Section 69 appeal.
I anticipate that's the case. I don't know myself without checking, but from the comments, that was my takeaway. So the main issue for determination was whether the key provision in dispute here, and we'll talk about that in a moment, whether it was a condition or an intermediate or innominate term. And as we said at the outset, that concept itself was relatively new is, I'm not sure the right way to put it, but it followed on from the Hong Kong fur case. And in a bunch of cases, the courts were looking at, well, is this type of provision that we're dealing with one where it is a condition, either expressly or impliedly set out by the parties to be a condition? And there's some useful framing of how you assess whether a term is a condition or not in this decision. But that was kind of question number one. And then the second question related to that was whether the particular term that was in issue here, and that was whether the buyer was to give to the seller 15 days notice of the probable readiness of the buyer's vessel to load, whether that was a condition or an intermediate term. And that was a term that came from GAFTA 119 at the time. And it's, as you can appreciate, it's a time-based provision. So this is one of the leading decisions on whether a time-based clause in a sale and purchase contract is of the essence, whether it's a condition going to the root of the contract. And so it's a really fundamental case to know and to look at if you have a dispute around a time-based provision, particularly in a sale and purchase contract, and what's the consequence of that if it's breached.
Exactly. And what had happened in this case was that there was an agreement to sell and to purchase 15,000 tons of soybean meal in 3 separate shipments. So each shipment was going to be 5,000 tons, and they were going to take place in the months of May, June, and July. And each of those shipments had a long stop date, and it was for the buyer here, Bunge, to say to the seller, this is the point at which we're going to take the goods. And they were to give a notice of at least 15 days of probable readiness. And the final day for the May shipment was the 30th of June, 1975, which meant that when you kind of worked back and calculated the days, the final day to give the 15-day notice was the 12th of June. And in fact, the notice wasn't given until the 17th of June. And this was what the seller, Tradax, relied on to say, we get to walk away from the deal now. The fact that you've given the notice on the 17th of June means that you cannot give us 15 days notice of probable readiness of the vessel before the sale happens, and therefore the sale cannot happen within the contractually stipulated period, and the deal's off. You are in repudiatory breach of the contract.
And so, yeah, it really throws up this question as to what type of term are we dealing with? And I wonder whether a useful place to start on the analysis, Calum, is just to set out the types of terms we're talking about, which really follow on from, or which was set out in the Hong Kong Fur and Kawasaki Kissen Keisha case of 1962 Court of Appeal decision, where it said the Court of Appeal rediscovered and reaffirmed that English law recognises contractual terms which, upon a true construction of the contract of which they are part, are neither conditions nor warranties, but are intermediate. And so I think that's a good place to start. And the case sets out here what each of those terms are with a really helpful kind of definition. And I thought this might be useful just to read these out. It says that a condition is a term, the failure to perform, which entitles the other party to treat the contract as at an end. Okay, so condition, very important term, goes to the heart of the contract. And if it's breached, the other party can walk away from the contract and call it at an end and claim damages. A warranty is a term, breach of which sounds in damages, but does not terminate or entitle the other party to terminate the contract. Again, this is a lower order term, which if breached, you can claim damages if you can show that you've suffered damages as a result of the breach, but you can't walk away from the contract. You're still stuck in performing the rest of the contract as the non-breaching party. So that's the second term. Two ends of the spectrum, condition at the top end, very important term, going to the root of the contract, and a warranty, which the breach of which sounds in damages. Then you have this term in between. And the definition of that, as stated here, is an innominate or intermediate term is one, the effect of non-performance of which the parties expressly, or as is more usual, impliedly, agree will depend upon the nature and the consequences of the breach. So it's this concept which was set out in the Hong Kong Fur case, where you have a term that sits between a condition and a warranty and can kind of go either way depending on the consequences of the breach. The gravity of the breach term, as was referred to here by Lord Wilberforce.
The Hong Kong FIR, the issue there was a breach of the obligation for the vessel to be seaworthy. And you can see why on the scale of kind of a breach of seaworthiness, you could have something which is completely disastrous to the ship or completely unsafe for the ship to be sailing in its unseaworthy condition. But you could also have something which is much more trivial, and yet still renders the vessel temporarily unseaworthy. And let's say it's an 8-year charter party, and there's a requirement for it to be seaworthy throughout the duration of the charter party. If it very briefly falls into an unseaworthy condition, then that's not necessarily something that would entitle the charterer to say we want to terminate the charter party. And that was the obligation that was at issue in the Hong Kong FIR.
Yeah, and it's the example used was, you might have one nail that is out of place on the ship, or you could have a hole in the bottom of the hull, right? I think, yeah, okay, that makes the point. But it's these kind of obligations or terms where you need to look at, well, if it were breached, and if it is breached, what's the consequence of that? And so what was happening, this was set out in the Hong Kong FIR in 1962. We're now, almost a couple of decades down the track from that. And you've got a number of cases that are exploring the contours of that. And what you have here is, well, the courts were kind of reluctant or careful to separate those types of terms where you have this kind of qualitative analysis or this assessment of the consequence with terms which are just plainly conditions, and they make a lot of sense to be conditions. And as I said at the outset, a time-based provision is much more straightforward in some ways. If you have a date and it is missed, and it's very easy to kind of assess from the outset, at the time the contract was formed, what could be the consequences of that. And I thought that was a really useful way when I went back at this to think about, well, if you're assessing whether a term is a condition or an innominate term, what would it look like at the time the contract was entered into? If you had to conduct the analysis before anything happens, and you're just looking at the term when the contract was formed, if you're looking at it and it's very clear that breach of that term could lead to some significant consequence, or a lot of reliance may be placed on it, and the examples that were used here were string sales, for example, where you might have back-to-back sales, all dependent on certain dates, loading dates, when a loading period is triggered, etc. And there couldn't be a lot of reliance by the parties on that date. It's not just it's an advisory date that we can ignore. No, it's a date that needs to be complied with.
It's a really good point, and this is kind of how it was put by Lord Wilberforce, who said there are a number of different ways that you can be unseaworthy, and this is in response to an argument from Bunge that there's a gradation here because somebody could be 1 day late or they could be 100 days late. And they said, look, those two concepts are very different things. Us being a day late or us being 4 days late, as we were, is entirely different in gravity to us being 100 days late. And Lord Wilberforce said, that might be true, but you're missing the point. And the point is that if you look at seaworthiness, then there are a number of different ways that you can be unseaworthy. So we're not talking about how serious each of those things are. We're talking about the different ways that you can be in breach. Whereas here, there's only one way you can be in breach.
Yeah. I like that. I like that, Calum. I think that's a really good way of putting it. Sorry, I interrupted.
No, it's because I when I read that from the rule before, so it slightly crystallized in my mind as well, because I was reading it thinking, well, yeah, you can be a day late, and that seems very harsh, but it's the way that he phrases it in his judgment is excellent, because it does draw that distinction that there's only one way you can breach this: lateness, whereas unseaworthiness, you can breach it many different ways. And the other point you raised there, Luke, which really comes through in this judgment as being super important, is you don't start from the effect of the breach and work back to say how serious the clause is. You have to start ignoring that the breach ever happened and say, what level of seriousness did the parties put on this clause at the time they entered into the contract?
Exactly. That's exactly right. And it's this, it touches a little bit on implied terms as well, this decision, in that when, as often the case, you're looking at whether a term is a condition or something lower than a condition, it's often not set out. If it's set out, it's not going to be a dispute about it. So you're often looking at it from the perspective of what the parties had impliedly agreed. And a condition is when, if you were to ask the parties at the time they formed the contract, well, is this a condition or not? The parties would say, of course it is. It's that kind of test. It goes to what makes sense, what gives effect, business efficacy, right? What gives effect to what the parties had intended to achieve here. And the idea that the time-based clauses like this can just be, brushed off, and you're a day late here, a day late there. Well, no, that's not what the parties would have expected or have intended when they're entering into those types of terms.
And this is what Lord Lowry said, where he said that you can do this analysis as soon as the contract is made.
That's really critical, isn't it? And I think it's useful to approach this type of analysis whenever you have these kinds of terms from that starting place. Like, forget what has happened. Put yourself back in the shoes of the parties when they're forming the contract and ask yourself, what were they intending to do here? There's a great line in here, and this is more kind of back on, well, and this was on Lord Scarman explaining the Hong Kong Fur, and that what the Hong Kong Fur did was, it says, well, there are other terms out there beyond just conditions and warranties, and that was exposed in the Hong Kong Fur. But then he went on to say, and I like this line, to read the subsection as a guide to a comprehensive classification of contractual terms is to convert it into a will-o'-the-wisp, leading the unwary away from the true path of the law. Do you know what a will-o'-the-wisp is, Calum, off the top of your head? I do now, having read it. But it's one of these classic lines where, you realise that you're reading something that's perhaps, from a different era, different time, when these phrases may have been known. I don't know whether anyone still uses will-o'-the-wisp, but I'd not heard it before. And so I looked it up. Will-o'-the-wisp in folklore is an atmospheric ghost light seen by travellers at night, especially over bogs, swamps, or marshes. In literature, will-o'-the-wisp metaphorically refers to a hope or goal that leads one on but is impossible to reach, or something one finds strange or sinister. That's from Wiki. So I learned something. Other than looking at some law, I learned something in reading this decision. But a will-o'-the-wisp. Anyway, so where were we?
I think what it leads to is, in this context, in this judgment, in the context of the agreement entered into between buyers and sellers here, why is this deadline a condition? Why does it reach that threshold? You know, that you can, if you're a minute late, a second late, if you're late, then you're late, and that's it. The other party is entitled to terminate the contract. Why is time so important in these mercantile contracts?
Yeah, exactly. And I thought Lord Lowry's judgment was quite useful on this, Calum, in answering that. I think it's 12 bullet points or numbered points, not bullet points, numbered points were set out as to why it should be a condition. I thought it was quite useful. And that followed on from a quote from the Moorcock case of 1889, which, looked at this. It's kind of what we were talking about before about in business transactions, that the courts are there to give business efficacy to the transaction. And there's a great quote in there on page 720, which I'd recommend. It's a long one, so I won't read it all out, but it's a passage that, according to Lord Lowry, has stood the test of time, and I commend it to all lawyers who undertake to advise their clients on mercantile affairs. That's a pretty big statement, right?
It is, and actually I went back and reread it.
Yeah, I did. I reread it. I read it, read that line, I'm like, oh, I better go reread that.
Yeah, me too. I am a lawyer who undertakes to advise my clients in mercantile affairs. I should make sure I reread that. It's been commended to me.
I'm like, we need to copy and paste that and send it around the firm, I think, Calum.
Yeah, we do. Certainly to all of the lawyers at the firm who undertake to advise their clients on mercantile affairs.
Yeah, there's a few of them. A few of them that try anyway.
A few springs. No, but I think you're right. I think that the Lowry judgment was excellent for this, and one of the things that comes through very clearly is that there's a proper understanding of the way that the importance of time in these string contracts, so the effect of the onward sale, and requiring the certainty to say, okay, but we need to sell this on down the chain or purchase this on up the chain, and you can't leave us. You can't leave us in a position where we're exposed. If you have a deadline, you need to give us the answer by that deadline.
Yeah, and I also thought there's just this kind of overriding theme or point that's being made in this decision, that there needs to be a black line at some times, or a red line, or whatever it is, where, if parties agree on something, they have agreed on something, and they should be held to that agreement. Like there was almost like this sense coming through, well, if parties are going to enter into contracts with a deadline, which you can, we've had some deadline cases that we talked about elsewhere, but you've got a deadline. You know what it is. They then enter into subsequent sales based on that deadline. Payment can be triggered on that deadline. You can pull out of the contract on if that deadline's missed. It's really important, and we know this. Like we've been dealing with cases during our careers on just an absolute understanding that these time deadlines around loading periods and what have you are serious. They're conditions, and proceed on that basis. And it's interesting looking back to a decision like this, where it was up for debate and it went all the way to the House of Lords, and had gone both ways on its way through the system, right? But you're right. It comes back to this question of certainty. Comes back to the commercial practice here of string sales. Not just that, but there's a really strong kind of sense that the commercial setting is important, and it's actually going to be one of the points that I make in this upcoming course, without giving away the course before I do it, Calum. But how the English courts, and not just English courts, but it's what we're focusing on here, how they look at the law, and they espouse the law, particularly in mercantile areas like this, commercial areas, with a clear sense of what the parties were trying to achieve commercially. And it comes through time and time again. This is just one example of that.
And it comes through by reading cases. For me, it's one of the revelations of doing this podcast, and actually going through the process of really sitting down and reading front to finish a case that's new every week. You feel the way a court makes these decisions, and the things that are persuasive to a court are not necessarily the kind of pure construction of a single sentence. I guess in a way the temptation when you're at law school is to think of the case where the misplaced comma changed the whole meaning of the sentence. But that's very rare. And actually what happens much more routinely is extraordinarily experienced and very experienced in law, but also very experienced in general commerce. The judges now, particularly in the commercial courts, the Court of Appeal and all the way up in the English system, understand these contracts inside out, whether it's a charged party or a sale agreement or a GAFTA terms, whatever the contract is. They understand the commercial context really well, and they can make very reasoned decisions based on the commercial background to the deal. And that is often at least as important as looking at the individual words and finding the right construction of the clause to suit you at any given time.
Yeah, it's a really good point. And I think there's another point to make on that, Calum, and that is how does the law then work as a guide for its users, for the commercial players out there. So you've got when looking at legal issues, as you're describing, the law needs to work in tandem or make sense from a commercial perspective. But also, once pronounced, once the law is there and the law, exists and it's set out clearly, what is going to be the flow on effect? What's the utility of the law, if you like? And I think particularly at this level in the House of Lords, but throughout the court system, there's this sense that the law needs to make sense as well. And I say that with the greatest respect, and I'm not sure I'm explaining myself well, but what I mean is, in this situation, the House of Lords was conscious that if this type of provision was not a condition, and if it was an innominate term, and parties then in practice after this, dealing with these time-based type provisions, had to start looking at the severity of the consequence on every single time and try and work out, well, what has been the consequence of missing this time? Is that enough to now rescind the contract, or does it only stand in damages? There's a lot of uncertainty there. It may create more disputes. You may have disputes running for many years without a clear answer on some of these points. And so there is this, there's this element to it about how would it play out in the future, right? How would it play out in the future? And it's not always the case. Of course, there's we could spend a whole podcast talking about innominate terms, and terms like the one in the Hong Kong FIR, like the seaworthiness obligation, which you do need to look at the consequences and then start to work out, well, what can you do now by way of remedy? But in situations like this, where certainty is available to the court to take, and it makes sense in a commercial setting, the court's going to go that way.
Yeah, totally agree. And that came through very, very strongly throughout the judgment. But even in the principles the arguments that weighed heavily in Lord Lowry's favour of saying this was a condition, if you go back through those, then they're almost all of them of kind of ubiquitous application to these types of contracts. He doesn't say, in this particular context, this makes a lot of sense. He says, if this was to be an innominate term, parties in this position generally would struggle to work out the correct loss, or parties in this situation generally would struggle to know what to do in a string contractual chain setting. So certainly when you get to this level, and the decisions made by the House of Lords, as it was, or the Supreme Court now, there's always half an eye on the broadest possible application of the law. And as you say, it sounds, I don't think it sounds disrespectful, but it doesn't quite put the right point on it, but it is this equally what's coming to my mind as well is just making the law make sense, making it user friendly, and making it clear so that people can actually use the law. If people can use English law as a basis for their contracts and know what the outcome is going to be.
Yeah, I found the quote I was thinking about, Calum, in Lord Lowry's decision. It was his last numbered point 12. Arbitrators and courts might, if the term were innominate, give different answers concerning the effect of a breach in very similar transactions, and parties could never learn by experience what was likely to happen in a given situation. So-called string contracts are not made or adjudicated on in strings. It's this concept that there needs to be certainty for commercial players. They need to understand what the law is going to do. It's one of the real hallmarks of English law. I think it's one of the strengths of English law. It's why we're looking at cases here in the 80s, which are referring to cases from the 1890s, and they still have relevance, and why English law is still the prevalent law worldwide on these types of issues. It's because of these types of considerations that are coming from the top about certainty, about providing a platform for commercial parties to know what the situation is. So important in many ways, this type of decision. I really enjoyed reading it. Did you have any other kind of final comments that you wanted to make on it?
Yeah, so there's one, just drawing a comparison between these types of sale contracts that where we know that these provisions for payment are provisions regarding time for the nominating the period during which the sale is going to happen, or giving notice of the readiness of the ship. We know that those are conditions of the contracts following this. It's interesting. It's interesting to me in reading this case from the 80s to see the way that the law has moved away from finding conditions in charter parties in recent years. And I think there's an interesting comparison to be drawn, where I think it's actually very difficult to say whether anything would currently be a condition in a charter party, especially from the charterer's side, given that payment of hire punctually is not considered a condition. A recent case also found that from the owner's side, keeping insurances over the vessel was not a condition. There's almost been a movement the other way in the charter party context to say there's actually very few things you can point to say this is a condition of this contract. And I was interested in that comparison between the sales contract side of international trade and the charter party side.
Interesting. Yeah. I think also there's a historical context to this decision and when it's being decided after the Hong Kong fur. It's almost a bit of the pendulum, right? The pendulum of the Hong Kong fur has taken the law one direction, and I got this strong sense with this decision that it's reining it back in a little bit, saying, oh, hey, we still need to assess whether certain terms are conditions, and you might not get past that analysis to get into looking at an innominate term. And this is one of those situations where it is a condition. It's a condition for all these reasons. But it's interesting, just in the case that they distinguish it from, if you like, in the Hong Kong fur, you're looking at a seaworthiness obligation, right? Which is kind of the point you're making. So yeah, fascinating. I also think, and probably my final point that I'd make on this is, I think it's important that we do these cases every now and then, look back at decisions that were decided in the 80s or the 60s or 2 centuries ago, to one, understand the origin of the law, one, understand where certain fundamental principles that we deal with originally came from and how they were developed, but also to then start to think about, well, as you just brought up, Calum, what are some of the issues we're dealing with today that if you look through it through the prism of an older case, is there something to nudge at? Is there a new, creative, novel argument? Well, new, I don't know if it's the right word, but is there a creative way of arguing something in this day and age, something that we've been dealing with in current authority, that through an older case just looks a little bit differently? And I think there's something to that. I definitely think that process of the common law and building upon itself and narrowing certain ways, expanding in other ways. If you have a concept of the English law over a longer period of time, it helps you to come up with more creative arguments now.
And you see it sometimes in hearings. If you're watching, masterful advocacy, it's never a case of somebody saying, well, that case doesn't quite mean what you say it means because the judge could have meant this instead. It's never that superficial. The really top advocates will go back to the case principles, and they'll say, this is where this principle comes from. This is how it's kind of moved and shaped over time. And this is why that latest judgment in the series, in fact, says what we think it says rather than what it seems to say on the words. That paragraph actually refers to this Court of Appeal case from the 1980s, or this House of Lords Court case from the 1950s. And as the laws come through from first principles through to the law that it is today, you can actually see more clearly that, long story short, we're right, they're wrong. But it is that knowledge of the entire history of the case, of case law that really you can see sometimes in the judgments as they go through the case law, to make the point that the law has always been this way, which is the common law system. But sometimes also when it's one of our own hearings and we're in the hearing, and if there's a King's Counsel or an extremely accomplished advocate, then you can see those arguments being made in real time, and it's an impressive thing to see.
And also looking at how the case was argued. So, if this was the decision that was put down by the court in this older case that you're looking at, how were those arguments brought out? Like, how were they ventilated? Was this a key issue? Was this something that the court really assessed? Or was it just a kind of some obiter dicta that's by the by and has been given this prominence in a submission that's now before you? But actually, when you look back at it, was it really before the court? And then another case, it was actually really before the court. Like here, for example, I think we haven't talked about it, but you had this quantum question about whether damages should be assessed on the minimum quantity here that could have been provided. There was a tolerance issue, and as we know, the non-breaching party can only claim the minimum amount that the contract would have performed if there's a range, and it didn't get much airtime at all in this decision for good reason. But if I was looking at that point, I'd go back to the Court of Appeal decision on it to get the actual authority, but I would then use the commentary from this House of Lords decision that basically said, why was this decision even put before us? It went through 14 others to get to us. It shouldn't have been here. To kind of put an exclamation mark on the ratio that came from the Court of Appeal decision, and it's that analysis which, had I not read this case in such detail for this purpose, would I have known that point? I don't know. Maybe had I been doing the research for a particular case, I'd like to think I would. But that's what you see. As you say, a top QC would do, and yeah, it's just I just find this process of thinking about cases not just enjoyable but really useful in terms of our practice, and setting us up for advising clients. Okay, all right. Well, thank you everyone for listening in. I hope you've enjoyed the discussion today. We've gone back in time again. We'll do it one more time next week for our 50th episode. Can you believe that, Calum?
The big 50. I remember at some point earlier in the year, around February, you said, let's get to 50 by the end of the year. And we're going to have our final episode of the year, our kind of Christmas sign-off will be our 50th episode of the year. I'm going to dig out that message and send it to you after this. It's a long way deep.
Never even me, Calum, that's for sure. I don't remember that, but it's probably something I said off the cuff. Not expecting us to get there, but we do deliver, mate. We do deliver. All right. Well, look, thanks for listening in. And until next time, take care. See you, Calum.
Cheers, Luke. Bye.